Good morning, afternoon, evening. Of course, that depends on where you are in the world. I am LeTonya, your resident brand protection attorney, and wanted to drop in again and share a really short brand protection tip. So, guys, this is very important, right? So you have heard me talk about online contracts and some of those dangers. I have had an influx, and I've talked with some of my colleagues as well. And I'm going to have a couple of other experts who can do some lives with me, and they're going to be a part of some of the brand protection. What other lawyers want to tell you? We're going to start doing a lot of these because it's really important that you guys are educated, that you know, and so that whatever decisions that you make, you can have additional information to include in your analysis before you start to do some things that are really, really going to be far more detrimental and far more costly than just using an attorney from the beginning. And so I want to talk today about the dangers of using online trademark services. So I'm just going to say, if you know someone that you care about, you need to make sure that they're tagged. You need to make sure that you share this video with them. If you yourself are considering this, some people, and let me throw this out there, these are just the downsides. So I want to make sure, because you're going to have some people say, well, I use the online trademark service. I didn't have this problem. So of course, people that don't have the problem, I mean, we're not talking to you, right? But you may have the problem later on, and it may be that you didn't have the problem with that particular trademark. So I want to talk again about some things that you need to be aware of when you're using online trademark services. So I want to share a little bit of a story. Someone reached out to me, a small business owner. They had utilized the trademark service a couple years ago. And the facts as were told to me, because again, I was not involved in this process, but the facts as were told to me is that they submitted all the information that the company asked for. They paid the company and all of that. Long story short, this was a couple of years ago. So they had no idea. They had already sort of been primed that it's a long process and all of these things. But this particular request that this person was making, honestly, should not have been a 2-year process, and they still had not heard anything. So when they reached out to me, because they were following up with the company. They were reaching out to the person that was assigned. They were not getting in contact with that person, only to find out that person had left the company almost a year ago, and no one was giving them any information. So I want to say about 2 or 3 weeks after this person had been very persistent at reaching out and all of those things, they receive a letter, an email, basically saying, hey, you didn't get the trademark because of you failed to properly respond, right? So the person, again, the facts that they told me was that they responded to everything that this attorney asked them to do. They sent information that they were asked to send, and so they didn't understand what was going on. The company was not being responsive to them. And at this point, they had spent, I want to say, the person said about $1,500. Now, mind you, this was an online trademark service. Now, of course, some lawyers do charge $1,500. Some of them charge more. But let me say this. So in the end, so what they wanted me to do was to find out what happened, right? So they brought me on. They wanted me to find out what happened for them. And essentially, this is what happened. They did everything that they said that they did. They did everything that they were supposed to do. There is something called an office action that comes back, and all that means is that the U.S. Patent and Trademark Office has a question, right, that they would like for the applicant to answer before they make a final issuance of the trademark. Now, let me tell you why that's very important in this particular situation and a lot of other situations, because basically in this analysis that had gone from the U.S. Patent and Trademark Office, they essentially said, look, we've checked everything that you sent in. We've done the research. We believe that there is no other trademark out there. There's no infringement, blah, 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 all the other legalese and things that they say, which essentially means if you send us this information or answer the question, we will take that under advisement and immediately issue the trademark. He says that information was never sent to the U.S. Patent and Trademark Office, and he was able to show that he responded when that information came up. He was corresponding with the particular person who was handling his application. You know what happened? What he had clearly missed was they told him he had to pay another $299 for them to submit the information on his behalf. So he missed the request for additional information. According to this particular person, they thought that the correspondence was saying that they had already paid. And if you read it, I know, but if you read it, it almost sounded like that. So I think that they just misunderstood the correspondence. Now, they didn't talk on the phone to this person. They only corresponded via email. Again, there was a big gap. Now, there may be some things that this person can do to revive the application. Of course, depending on the time frame that has passed, they are probably going to still have to pay another filing fee because so much time has passed. Someone else may now have a competing mark in the marketplace, or they may have actually filed an application or been approved. What I'm telling you is, in this particular situation, what is so grave and why I wanted to do a video about this is because the very things that they were asking about are the things that should have automatically been done just anyway. There are certain things there's certain words and certain items and things of that nature that you cannot stake an ownership claim to. You have to just let the U.S. Patent and Trademark Office know that up front. Now, any attorney that does intellectual property, they know that. So they automatically have their clients fill out those, pretty much a disclaimer, right? Basically saying, I'm not trying to trademark just this, I'm trying to trademark that. And so it clearly lays it out so that you don't have to worry about an office action coming back. You don't have that problem. You don't have to worry about whether or not it's going to be held up. And most importantly, you don't have to worry about having to spend additional money. And so if you think about it, for example, this person had already spent $1,500, right, with that particular online company. They had waited now over 2 years only to find out that there was this one thing that needed to be done, that it may be too late to do. They paid me to do pretty much a backwards investigation to backtrack exactly what was going on because no one was communicating with them. And so essentially, he paid more and still doesn't have the trademark, right, than if he had just utilized an attorney. Because what he told me was he went with this company because he was saving roughly, at the time, roughly about $1,000, okay? Now he has a choice to make. Of course, I educated him on what the discrepancies were in his application, what had gone on, some of the things that I'm sharing with you guys. Of course, we went into an in-depth conversation, but I let them know what the situation was, what the problem was, so that the next step, they can fix it. If they go through another online trademark service, I hope that they don't, and I have discouraged them from doing that. And I've also connected them with some people that I utilize, that I trust, because some things are just complicated and you want to make sure you have the best person who's handling that particular part of it. Why am I telling you guys this? Why am I sharing this with you as a brand protection tip? Because oftentimes people really believe that it is cheaper to do the online route or the DIY route. Some things you just cannot do yourself. If you are going to do it yourself, you need to make sure that you are armed with as much information as possible. And quite frankly, there are just certain things that you're just not going to know unless you learn it from a lawyer or someone that is very well versed in the subject matter. Because there are people that deal in intellectual property, they have patents and things of that nature, so they know. And so if you have a mentor who has done that, you want to talk to them, certainly for sure. But if not, it pays to get a legal consultation, a legal review. Oftentimes, if you don't have enough money to pay, a lawyer will say, well, I will review it for you, and this is what my review is. I tell people to do that all the time. I am not a big proponent of online anything, because let me tell you what else could have happened. Had they gone to an attorney and had the same experience, then they would then potentially have a malpractice claim, which means he would have got his money back. Not just for the original trademark, but any money that he spent to fix this, right? He would have had a claim, he would have got his money back. You don't get that when you're dealing with an online service. You just don't get that. And so you need to really understand the full story, the full implications of that. Again, one of the things you guys may have heard about this, if you follow me in anywhere really online, is that I'm launching something called the Brand Protection Academy, which it's a legal education series. You can check out the description, but it's a legal education series. Of course, it's geared towards legacy-driven entrepreneurs. It's geared toward people that are serious about taking control of the legalities surrounding what they need to do with their life, their business, their legacy, and the people that are really wanting to get educated on what do I need in this situation and what do I need to do. Now, of course, it's geared towards things like intellectual property, asset protection, contracts, things of that nature, how to protect yourself against, taxes and things like that, which of course is geared more towards the people that are really looking at building wealth and building a future. And there is a link. You do have to apply to be a part of the academy. So it's not something that you just go and sign up for. You do have to apply. We will review the information because we want to know that it's people that are serious about being committed, right? Lots of people spend a lot of money, but if you're not going to utilize the information and apply the information, it's probably not going to be a good fit for you. I'm just going to be very honest. If you're not going to do that, if you're not going to do the work, it's not a good fit for you. But there is a link in the description where you can go. There's no obligation. Just because you apply doesn't mean that you're obligated to continue on in the process. But before I leave you today, I want to encourage you guys to join our 360 Brand Protection Facebook group. I drop a lot of knowledge over there. Make sure that you like the I Protect Your Brand with LeTonya Moore Facebook page. But more importantly, beware of using online services for your trademarks. Oftentimes, it ends up costing you far more money than it would have cost you if you had utilized the attorney. So again, thank you guys so much for spending time with me today. Until next time, have a great day.